Welcome to another virtual CPE meeting on succession planning through will. Very interesting subject. And we have today Advocate Basil Mathew and Advocate Ninan John, advocates from High Court of Kerala, on this subject. May I request our chairman, C. Roy Varghese, to welcome speakers and all the participants.
Very respected faculty members, Advocate Basil Mathew and Advocate Ninan John, my fellow colleagues in Managing Committee of Ernakulam branch, senior members, colleagues and friends in profession attending this virtual seminar today. Good afternoon to all of you. This is the second CP program of the new year 2021. As you know it very well, major part of the year 2020 was loaded with pandemic COVID-19. We are now on to gradually settling to control the pandemic through new lifestyle as well as COVID-19 vaccines. Virtual meetings, social distancing and mask has become a part of our life now. This year, I believe it is proposed to have some of the CP meetings in physical mode and others in virtual mode. We are gradually starting our physical sessions. Already we had 3 physical sessions. The first one was the Formation Day meeting on December 1st, 2020. And the second one was the interactive meeting with the President and Vice President on 8th January. Yesterday, we started our study circle meeting physically. Hereafter, all the study circle meetings might be in physical mode, and all the meetings will be as per the strict COVID-19 protocol. We are going to have our budget analysis on 2nd February in physical mode, admitting limited number of members at ICAI Bhavan, Ernakulam. The details of the meeting will be given by KV Joss, Secretary. Kindly register in advance and reserve your place. One request especially to the ARS members. Do not simply register in advance unless you intend to attend the session in physical mode, because you will be denying the chance to another one. Further on 2nd, we are arranging lunch also for the registered participants. If you register in advance and not attending, you will be wasting the food arranged also. So please keep this in mind, and if you register, see that you positively attend the session. Coming to today's session, it is important for every person to plan his or succession at family level as well as for the business. Succession planning is a process and not an event. In India, like much else, succession planning can be quite complex. Families are often large or small with several factions and with multiple people involved in the business. Deliberations around succession planning can be long and difficult, making it imperative to involve an arbitrator or mediator or an advocate or a chartered accountant. The slew of regulations around tax and other regulatory matters, in addition to the personal laws, make this more complex. Will remains the most oft-used mechanism for passing down wealth through generations. It has its own inherent limitations and benefits also. The chances of a will being challenged, tying up the family in litigation for years to come are high. It says every person, particularly after the age of 50, must prepare a will to provide for a smooth litigation-free transfer of assets to his or her family in manner in which he decides. There are certain important aspects of making a will which should be taken care of so that a valid will can be properly drafted. Besides, there are various income tax advantages to legalities and other members of the family through a proper drafting of one's will. Today in this session, our learned faculties will discuss with us on the law relating to will, types of wills, how to properly prepare and draft a will, registration of will, etc., etc. And in the process, they will enlighten us with various benefits, implications, and other challenges also. I am sure this session will be very useful to all of you present here today to attend this session. Advocate Basil Mathew and Advocate Ninan John are practicing advocates of High Court of Kerala, well versed in the subject. We are happy to have them here today to take the session on succession planning through will. On behalf of Ernakulam branch of ICAI, I extend a very cordial welcome to Advocate Basil Mathew and Advocate Ninan John to this session. Welcome. All our branch managing committee members are present here today. I'm really happy that. I welcome immediate past chairman C. S. Srinivasan, vice chairman C. Nijit Pariyar, secretary C. K.V. Jose, treasurer C. Deva Varghese, Sikasa chairman C. Alan Joseph, and circle coordinator C. A. Salim to this session. Now it's my pleasure to welcome each and every one of the senior members, colleagues, and friends in profession who are attending this session. Hope you will have a very enlightening and informed session today. Stay safe and healthy. I conclude. Thank you very much for your personal listening. Or to Joss for further proceedings, please.
Thank you, Chairman C. Raj Varghese. Now may I request C. Alan Joseph, Sikasa Chairman, to introduce our speakers for this afternoon.
Thank you, sir. Today we have with us two distinguished advocates, Advocate Basil Mathew and Advocate Ninan John from BM and Company, a well-established legal house based out of Cochin. Advocate Basil Mathew started his legal career in 1993 after completing his law graduation from Law College, Trivandrum. He established himself as a great lawyer under the able guidance of late Advocate C.K. Arvindaksha Menon, a stalwart in trial courts. His expertise is in civil law, focusing on conventional civil matters, real estate, rent control, family matters, banking, and writ matters. Advocate Basil is a standing counsel representing Kerala State Maritime before various courts in India. Advocate Ninan John is a corporate lawyer practicing in Kerala High Court with over 22 years of experience. He specializes in transaction advisory and civil litigation. Transaction advisory services are primarily in commercial contracts, company law, information technology, intellectual property, startups, and investments. Advocate Ninan is also the mentor for various companies under the Kerala Startup Mission. With these words, we invite Advocate Basil Mathew and Advocate Ninan John to commence their session. Thank you.
Thank you, and good evening to all distinguished members of ICAI Ernakulam. It's definitely our privilege to be here. And before we start, I think we should thank the invitation and the support given by Chairman Roy Varghese and Secretary Jose KV. Many people in the group is known to us personally, but definitely it's a proud privilege to be among the chartered accountants, one of the noble professions in the world. All professions are noble, we definitely know that. But when we talk about chartered accountancy, a lawyer profession, legal profession, and a doctor's profession, we always see something which is very common among these three. We all try to get our clients or patients out of a difficult situation. We help them to do that. We also help them not to land up in a difficult situation. Like a doctor, a chartered accountant probably will help them with an IT income tax matter. And at the same time, will help your client to plan their assets beautifully so that they don't get into other issues. Similarly, a lawyer also. When it comes to a chartered accountant, you have you do a very beautiful role. The chairman was talking about will succession planning for your own personal purpose. But we feel that as professionals playing a very important role in the life of your clients, you definitely play a much larger role when it comes to asset management of your clients. So you don't actually help them with the asset management as long as they live, but you also help them with planning their assets and how their assets have to be managed once your client passes away. And that's an advice, that's a guidance which most of the chartered accountants, I'm sure, giving to their clients as of now. So when we talk about helping your clients to have their assets managed once they pass away, is nothing but the topic of the day, which is succession planning. So succession planning through will is our topic today, and we have with us Advocate Basil Mathew. So this session is planned in a way of a chat show manner, so that we don't get the monotony of an online presentation. That's something which we wanted to avoid, because we are all fed up with this online typical presentation. So we thought of a different method, which we have tried it out in various sessions, where we actually do it as a chat show. So today, Basil, we will be asking you about most important aspects of certain things. But before we get into will per se, I think it is important that we start with interstate succession.
Exactly.
So what exactly is interstate succession?
Interstate succession means if a person died without executing any document regarding his succession, that is interstate succession. So in that event, the legal heirs of that particular person will step into the shoes of the original owner as a co-owner as per their respective personal law.
So when you say respective personal law, so it can be different for a Hindu, it can be different for a Muslim and Christian, right? So what about a Hindu interstate succession?
As far as Hindu interstate succession is concerned, the law applicable is Hindu Succession Act. There are three categories of legal heirs. Class 1, the prime members. Second, the class 2, the second degree of legal heirs. Third, the agnates and cognates. In class 1, the mother, the spouse and children of the deceased are included. But the mother is only having a limited right to enjoy the property or to take income out of the property. After his lifetime, his share out of the property will devolve upon the other legal heirs. She has no right to transfer his share out of the property.
So her is more of a life interest, I would say.
So one more aspect, if one among the class 1 heir is available, the property or the share will not go to the other classes.
Okay, that's very clear. So there is a class 1 heirs, class 2 heirs, agnates and cognates. And if one among the class 1 heir is available, then no devolution, the assets will not devolve to the rest of the. So that we spoke about Hindu succession, interstate succession. Now, what if it's a Christian? And for a Hindu interstate succession, which law is applicable?
Hindu Succession Act is the applicable law. And
what about Christians in that case?
when it comes to Christians, the Indian Succession Act is the applicable law. There, the wife will get 1/3 of the asset of the deceased, or the spouse will get the 1/3 of the asset of the deceased, and the remaining share, 2/3 share, will be divided among the children.
So what if they pass away without a child?
Then the wife will get 1/2 share of the spouse will get 1/2 share of the deceased, and the remaining 1/2 share will go to the other heirs of the deceased.
So basically, you spoke about Christian and Hindu. What about Muslims?
Regarding Muslims, the interstate succession is very complicated. We require at least 2 or 3 sessions to explain the basics of the Muslim succession. So
is that one of the reasons why we see very limited succession documents like will being executed in the Muslim community?
Correct, Ninan. A Muslim can execute a will for a maximum of 1/3 share of his property. That is the maximum he can bequest through a will.
See, basically, you spoke about separate personal laws, very clearly lay down principles of law when it comes to succession and interstate succession. If the law is very clear on that, why do we need a planned succession through documents like will?
In interstate succession, the legal heirs will step into the shoes of the owner and its ownership. They are only getting undivided share of the property. In the case of a planned succession, the exclusivity regarding the ownership can be extended to the owners. I can put an example now. Suppose a person having an apartment in Kadavandra, Kalur and Vaitila. He died in the state. Then the legal heirs, suppose he is having wife, son and a daughter. Now the wife, son and daughter will become the co-owner of all the three apartments. So they cannot, one person cannot sell, one person cannot mortgage or rent out the apartment to a third person. So the enjoyment of that particular, these three apartments are very restricted in case of interstate succession. But in a case of planned succession, suppose this person executed a will bequeathing the Kalur apartment to wife, the Kadavandra apartment to son, and the Vaitila apartment to the daughter. They will become the absolute owners of those properties. They can let out, they can mortgage, they can sell the apartments. So always a planned succession by way of will, settlement, gift, etc. are very good. In other case, it's only ownership, undivided share over all the properties owned by the owner.
In other words, Basil, that if the legal heirs are not in harmony and not ready to clearly value and then say, okay, this goes to this person, this goes to this person, it can definitely land up in a partition suit before the court and take the family into ruins.
Correct, Ninan. You know, a partition suit, it can be extended to decades. It can damage the very foundation of the family. So the ownership and the interstate succession is very dangerous. It will harm to the very foundation of the family itself.
That brings the importance of succession planning in a family.
Exactly.
So you spoke about will. You know, the person executing a will having this apartment with this person and this apartment with this person. What exactly is a will?
Will is a statement or a legal declaration of the deceased regarding inheritance of his property. So he is making a statement or legal declaration giving the properties to his beneficiaries or legatees.
Okay. So when you say it's a statement, what are the ingredients, the basic ingredients of that will? Can you just elaborate on that?
Yeah, basic ingredients of the will. One, you know, the testator.
So what do you mean by testator?
Testator means the owner of the property or the person who is executing the will, that we are calling testator. Then the beneficiaries, the legatees, that means the person to whom the testator is giving the property. Thirdly, the property, we need to describe the details of the property owned by him. And fourthly, minimum 2 attesting witnesses. Those are the main ingredients of a will, and an optional one, an executor for the proper execution of the will is an option for the testator. It's an optional ingredient for the.
Okay, so there are 4 mandatory and 1 optional ingredient for the will. Okay, so I get that point, but the critical question here is, we execute a will. When does that take effect? When does a will take effect?
Will not take effect on the date of its execution. It will take effect only the moment the testator passed away.
Okay, so it doesn't really matter. You know, we execute a will at the age of 40, and the person is still alive. The will does not take effect. Only when the person passes away, it becomes effective.
Exactly, Ninan. Even after the execution of the will, we can enjoy the property, we can take income out of it, we can mortgage it, we can sell it, there is no issue. We can enjoy the property up to our demise. It will take effect only from the death of the testator.
That's one of the major conveniences or benefits of the will. Basically, let's talk about the process of execution. This is very important as far as chartered accountants are also concerned. What can you step by step explain the process of execution?
Yeah. See, for preparing a will, the testator need to give instructions to the lawyer for the preparation of the will. The details, the identity, the details of the testator, then his legal heirs, the bequest, how he has decided to give the property to the person, the legatees. We will call it as legatees. How he has decided to give the properties to the legatees, and the details of the attesting witnesses. Details means the name and address of the attesting witnesses. Minimum 2 attesting witnesses. He need to give to the lawyer. On the basis of the instruction given by the testator to the lawyer, he will prepare the will and fix a date for execution. On the date fixed for execution, the testator has to call upon the attesting witness for its execution. There, in front of the attesting witnesses, he has to go through the will prepared by the lawyer, got convinced about the bequest made in the will. Then first he has to sign in all pages in front of both the attesting witnesses. Thereafter, the attesting witnesses also shall sign in front of the testator.
You said lawyer, in front of a lawyer and lawyer preparing the will. Is it mandatory that only a lawyer can prepare a will?
No, it's not mandatory that a lawyer alone can prepare the will. The testator can, or I can prepare my will, a scribe can prepare, or a person who is having conversant with the ingredients and the drafting of the will. Any person can draft a will. A lawyer is not a mandatory part for a drafting.
But the most important part, I think, is that the ingredients, the right ingredients has to be present in the will, and the technicality of execution also has to be followed clearly, because that is very important.
Exactly. The nomenclature of the document is not the criteria. What exactly is the ingredient? That is the criteria. There are certain ingredients to make a particular document a will. In the absence of such ingredients, it will not make a will. So a person who knows the ingredients of a will can easily prepare a will.
Okay. So a will is prepared. Do we actually need to register? Is it inevitable, or is it mandated that a will has to be registered before they start?
Will is not a mandatorily registerable document. It's only an optional one. You can execute a document and keep it with you. And on the other hand, you can also execute a document and register it before the registrar office. It's an option.
Okay. I can definitely see a couple of benefits when we talk about registration. Like a typical benefit is that when you lose the original of the will, it is very easy to get the certified copy. But in other cases, the will is lost, the will is lost.
Exactly.
Right?
Exactly.
So that could be one major benefit. Is there any other benefit for registration?
These are the 2 benefits.
Any other
one more benefit is this. If the will is being registered, the statutory compliance as per the Registration Act will be done by the registrar. That will give an added evidentiary value to the document. That will be helpful to the proponder or the legatees who is claiming under the will in case of a dispute.
Okay. That's a very important point. Like, and it adds on to the evidentiary value also. But here it actually brings us to an interesting point. Will is a document which can be executed on a white paper, is what we have learned. Now, when it goes to a registration, does it have to be on a stamp paper?
Actually, the will is not prepared in stamp paper. Will can only be prepared in white paper. Even if it is you have decided to register the document or will before the registrar office, it always prepared in white paper.
See, basically, when it comes to registration again, okay, let me delve more on the registration topic. will, as we all know, is an instrument which is not very expensive. But when it goes to registration, does it actually goes up on registration charges? Stamp duty anyway is not there, is what you said. But is it very expensive?
No, Ninan. Will is not an expensive document. The maximum expenses for registering a will is 1,500 rupees. You need to spend other amount for drafting the document. But in a register office, your maximum expenses is nearly 1,500 rupees.
Okay. Coming back, again on the topic of registration. Suppose I have a property in Kottayam and I am currently residing at Ernakulam. Do I have to go all the way up to Kottayam to have it registered? Because that's what we do in a sale deed, right?
That's a good question, Ninan. Actually, you can register a document where you do have a domicile. Domicile means a place where you are residing for a quite long time, nearly 1 year. If you are residing, Ninan, you belongs to Mavelikara. Your properties are there in Mavelikara. You can register a will there in Mavelikara, showing your permanent address. Since you are residing at Kakinad for nearly 4 or 5 years, you can show the domicile and register your will there in Trikakara. So the domicile is the criteria.
Okay. That actually is adding to the convenience of a will.
Second.
Okay. Now, you had mentioned that the will take effect only on the death of the testator. Does that mean that the testator can change his mind, his actual will, before his death?
That is one of the good part of the will. Even after the execution of the will, the testator can cancel the will, he can register a new will, he can modify a will. These are the options available to the testator. So till his lifetime, he can cancel, register a new will, and modify the will by executing a codicil.
Okay. That the codicil is the modification of the will.
Exactly.
Right?
Exactly.
Okay. So when a will is registered and there is an existing will and a new will is being executed by the same testator, the earlier will expires automatically.
Exactly. When the testator is executed a fresh will, the earlier will go.
So that again adds. I am coming back to the point of registration. Okay? So we were talking about registering a property in Mavelikara or Kottayam at SRO Kakinad. Now I have moved to Trivandrum. Now I am residing at Trivandrum. My first will is registered at Kakinad SRO. I am cancelling that will and registering a new will. Can I do it in Trivandrum?
You can do it if you are having a domicile in Trivandrum. You can register the cancellation deed there in Trivandrum. You can execute a fresh will deed in the SRO Trivandrum, provided you have to produce the original of the will before the sub-registrar Trivandrum. That is the only requirement for cancellation or execution of a will.
Okay. So that was a pretty elaborate explanation about the registration part. Basically, you mentioned about giving the property to our children, right? Suppose I am aged, my youngest son is taking care of me. I'm living with my youngest son. So definitely, I have an inclination to have a larger share given to my younger son. Okay. So is that possible? Since it is not undivided share, is it possible for me to have a disproportionate allocation to my legal heirs?
It is possible. Suppose the testator or I am the owner of 1 acre property and I am having more love towards my son. I can give 50 cents of the said 1 acre of property situated on the western side of this 1 acre property to my son, and next the middle portion 30 cents to my daughter, and the remaining 20 cents to my wife. It is possible. Disproportionate arrangement can be made or allotment can be made in a will. That is also one of the criteria or benefit of a will.
that again, going back to one statement that you made, when you were explaining the ingredients of a will. You said there is a testator, there is a legatee or beneficiary, there is a property, and there are the two attesting crucial witnesses. The second part, you did not use the word legal here. You used the word legatee or beneficiary. Is there any particular reason for it?
There's a reason, because as per the will, we can also give property to persons outside the family. He can also give property for charitable purpose or religious purpose. It is possible while you are executing a will.
Okay, that is, I think, a very, very big convenience compared to other documents. Like, in a very simple, in a very cost-effective manner, you can have the property transferred to someone outside the family.
Yes, it is possible. But one thing is there: if you are giving property for a charitable or religious purpose, you should execute the will at least 1 year prior to your demise. And one more aspect, the will has to be deposited at least for a period of 6 months. This is a criteria. If you are giving property for charitable or religious purpose, you need to execute the document 1 year before your demise, a minimum period of 1 year, and the will has to be deposited before the concerned authority at least for a period of 6 months.
Concerned authority means?
Concerned authority means registrar is a concerned authority for keeping the will. We can deposit the will before the sub-registrar.
So the point here to be noted is that if the property is also bequeathed by a person outside family, especially religious and charitable purposes, then additional care has to be taken. Anyway, you can't plan the death. So, you have to plan it early so that there is at least a 1 year gap between, the will is at least 1 year old so that the purpose is served. See, basically, again, going back to the registration, registration seems to be a very interesting topic. One of the basic or the most prominent benefits or convenience of the will is its secrecy. The reason why people go for will rather than other documents is because if it is a disproportionate allocation, the parents do not want their children to know about the allocation until their death. Okay, they would like to keep it secret. Okay. So when it is registered, don't you think the secrecy is lost?
No, secrecy. The secrecy of the will not be lost by the registration. There are one provision for making it complete secret. So if I am registering at my will and I want to maintain the secrecy, there is an option to deposit the will before the sub-registrar, and it will be opened only upon my demise. So it's an absolute secrecy regarding my will. You can maintain, there is such an option. The second aspect, the will is being registered in book number 3. Book number 3 is not applicable to, is not open to the public. So suppose a person is filing an encumbrance application for encumbrance certificate, putting it a certificate. The entries made in book number 3, like the registration of the will not find a place in the encumbrance certificate. So even if a person filed an encumbrance certificate, the entries made by the registration of the will not find a place. And one more aspect, the copies of the will be issued by the sub-registrar only after the demise of the testator. So if one, that is only to the legatee also. No stranger or outsider is entitled to get the certified copy of a will. So a legatee under the will can file an application before the concerned sub-registrar, and he need to produce the copy of the death certificate of the testator also. So both way, will is a good document to maintain the secrecy.
That's a very, very important and interesting aspect. To maintain, the legislature actually has thought about various aspects to maintain the secrecy of a document like will. listening to you, I think there are a lot of benefits attached or conveniences. I would say convenience attached to a document like will. Starting from the point that it is a document which can be changed because it takes effect only at the end of, at the death of the person. It can be disproportionately distributed. The cost is very minimal. It can be changed at any point of time, and it need not be registered, and the secrecy can always be maintained. There are a lot of benefits attached to a document like will. Now that takes us to obviously the second question: are there any shortcomings?
See, you can expect the danger also. Will is a suspicious document. Even though it is, there are a lot of ease for the registration and execution of the will. The evidentiary value of the will is less compared to other documents. When there is a dispute regarding the will, the person depending upon the will or relying upon the will need to prove the will before the court. So that is the main drawback of the will, even though it is very easy to execute.
So when we actually give legal opinion for purchase of property or mortgaging the property, if the property has devolved upon the title holder by way of a will, then obviously they raise it as a concern in the document, in the legal opinion itself, right? So that could be one of the reasons he has said that the evidentiary value of the will, since there are a lot of convenience attached to it, it brings down the evidentiary value of the document.
Exactly.
So in that case, how do we prove a will? How do we actually add on to the evidentiary value of the will and create it as a good document?
See, Ninan, there are two methods for proving a will. One, our voluntary action. We can file a probate OP before the district court, produce the original of the will in the said probate OP. The court will issue summons to the other legal heirs of the deceased. They will file their versions. Thereafter, the court will take the evidence. The person relying on the will can examine the attesting witnesses, at least one attesting witness, to prove that the testator executed the will with sound mental capacity. He understood the contents of the will. He signed the will in front of the attesting witnesses, and the attesting witnesses signed in front of the testator. And it's a genuine will. If such evidence he could produce before the court through the examination of the attesting witnesses, naturally, the court will issue a certificate to the effect that the will produced in court is a genuine will of the deceased. So that certificate can be utilized by any of the legal heirs for proving the genuineness of the will. Okay. That is one method. The other method, if someone among the legal heirs file a partition suit or any suit challenging the validity of the will, in the said suit also, the person relying on the will can produce the will before that court, prove the will through the examination of the attesting witnesses, got a judgment, a favorable judgment in your favor. That judgment also can be relied by all legal heirs who are relying on the will. That is also another.
Okay. So there is an involuntary action and there is an involuntary action. In both cases, the will can be proved, and then the evidentiary value goes up. See, the sum and substance of what you have explained, I think, is the role of witnesses. I think they are the critical and crucial. They play a very critical and crucial role in a will, especially after, because you are not there to explain that this is my will and this is what I want, right? So it is your witness who is going to say that, right? Can you explain more about the role of the witness?
See, the role of the witnesses. The dispute regarding the will definitely occur after the demise of the testator. So, the testator should choose two attesting witnesses, minimum two attesting witnesses, very credible, trustworthy, and a person who can explain well in court regarding the mode of execution of the will and the sound mental condition of the testator. Uninfluential person, a trustworthy person. So when you are decided to execute a will, you should find out 2 attesting witnesses with good quality.
Usually, in all the registration, you know how it happens in the registrar office. Like, most of the sale deeds registration, the witnesses are either the scribe's assistant or someone who is sitting over there. So the point is, when it comes to a will, never ever dare do that, and then the will is lost.
And that's a wrong method. The acquaintance is one of the criteria. The person, the attesting witness, should have the acquaintance with the testator. Then only he can be an attesting witness. He is not simply signing in the document. He is attesting the document. So the acquaintance is a criteria for a qualification for being an attesting witness.
One interesting point that you have mentioned, Basil, is that the capability of the witness to depose before a court. Because if it is a disputed, if it's a probate OP, undisputed probate OP, it's okay. People will come, depose, and there is no effective cross-examination. But if it's a contested partition suit, and partition suits are contested at the highest degree ever you can imagine. And if it's a contested partition suit, if the witness is not able to withstand the questions of the cross-examining lawyer, then it is gone.
Yes, the will go. That is one of the drawback of the will.
So in that case, my question is, see, witnesses are very important. Can I involve my family, who are going to be the beneficiaries, in the preparation of the will and make them witnesses?
See, that is not possible. A beneficiary cannot be a witness to the will. If a person took active participation in the preparation of the will and its registration, he is disqualified from getting a bequest in his favor. So, if any bequest is made in favor of that particular person who took active participation in the execution of the will, that bequest will become invalid. So, don't try to
Never ever
try to.
Okay. Basically, when we are explaining the ingredients of it, okay, the 5th item you said is optional, which is the executor. Can you explain more about that?
Executor is a person appointed by the testator for executing the bequest made in the will. I will put 2 examples. Suppose I am executing a will and appointing Ninan as the executor. I got 2 insurance policies for 25 lakhs and 25 lakhs. After my demise, the executor can go to the insurance company, collect the benefits out of the insurance policies, and divide this sum as per the bequest made by me, and you have to give to my legatees. Similarly, if I am the owner of 1 acre of property, I give western half 50 cents to my son, middle portion to my daughter, the eastern portion to my wife. Its property is lying as a contiguous plot. You can divide the plot, you can construct the compound wall, divide the property into 3 portions and give possession of the property to those persons. So executor is a person appointed for the execution of the bequest made in the will.
That explains that matter. Heard about different types of will. Okay, we have explained the ingredients and the benefits or the convenience of will. We have also heard about different types of will. What is it called joint will and mutual?
See, we were discussing about the individual wills. Now, joint will means it's an individual will, but 2 persons join together and they are creating their individual will by 1 document. Suppose, Ninan, you are having properties. Prema is also having properties. Both of you have decided to make your will. Ninan has got his own bequest in favor of the kids. Prema can have her own bequest. Both of you joined together and made 1 will, that is the joint will. On the other hand, mutual will is little complicated. It's like Siamese. If two persons creating a will under a contract, and one person got some benefit out of the demise of the other, and some benefit is given to the other upon the demise of the latter. So there is a contract between two, and such joint wills are called mutual will. Suppose, can I put an example? Suppose Ninan and Prema are executing mutual wills. Ninan said, if I died early, all my property will go to Prema. She can enjoy the property during her lifetime, and thereafter, as per the bequest made by me to my kids. Prema also, in the said mutual will, deposed that if I died early, my property will, Ninan can enjoy the property, he can take income out of it, and after your demise, it will go to so and so as per my bequest. So if Prema died early, Ninan is benefited out of it, and later on, Ninan cannot cancel the mutual will.
Okay. So when you say it's a contract between two people, unless otherwise it's mutually agreed to change, it is not possible to change. And if unfortunately one person has passed away, then it is not possible
It is
at all.
possible to cancel.
But joint will, on the other hand, is just keeping two wills together. They're still separate. Just kept.
Correct.
You saved paper in the process.
Correct.
Right.
It's two separate wills actually.
So when you when you were elaborating the process of execution of the will, you touched upon one particular word. You said the mental health of the person, the mental status of the person is very important. So I think that is a very critical element in the whole process itself. Right? More than the health of the person, it is the mental capacity of the person executing the will.
A will can be executed only by a person, a major person with a sound state of mind. So it is not the physical capacity, it is more the mental capacity of the person to be considered. Only a person having sound mental capacity alone can execute.
And that would be one aspect which is going to be examined in a partition suit or in a probatory, whether the person had the right mental capacity to execute when he was executing.
Yeah, those are one of the contentions taken by the lawyers in court to dispute the will. The other dispute is it's forged; it is not signed by the testator. That is another contention. So usually mental capacity is always it will be debated.
So that brings us to one last question. What is the ideal age of executing a will?
See, ideal age for executing a will, it depends upon the circumstances and the need of each individual. But I can point out two milestones. You can think about executing a will the moment you start acquiring property. That is the moment you can think of writing a will. And the moment you can, the moment your interest in the property, or you have decided to give the property to other persons, that is the other milestone. In between these periods, you can execute a will. That is the ideal period for executing a will.
Okay, so which means obviously you can execute a will only when you have acquired property.
Exactly.
So when you have acquired property, you can think about executing a will. But at one point of time, you think, okay, enough is enough. I have had enough of my property. Let me see others also, in my beneficiaries also enjoy the property. Let me see it on my eyes. And that between these two milestones is the right time to ideal age to execute a will. But with the moment you feel that, okay, fine, let me give it to my legatees, let me give it to my legal heirs, then what is the best document at that point?
That point of time, according to me, the best document is a settlement deed. So, settlement deed is a kind of if deed, that can only be executed in between the family members. So according to me, settlement deed is the ideal document if you have decided to give the property to your children, wife, etc.
Okay. But settlement deed is a document which has to be mandatorily registered.
It's a compulsorily registerable document. So registration is required.
Registration is required, which means that once you've done it, it is very difficult to change your decision.
The cancellation of a settlement deed is very difficult. So when if you have decided to execute a settlement deed, don't think about cancellation. It's very difficult.
Does the cost is it very high? Because definitely it can't be as cheap as a will. Is it a very high compared to the?
It's not very high. It's moderate. The cost is 1,200 rupees per lakh. That is the registration fee plus stamp duty for registration of a settlement deed based on the fair value of the property.
So the best benefit, see, when you compare two documents, basically, you can't say which is better or, as you rightly said. But the point is when the convenience goes up, you bring along a lot of risk also along with it. Since the convenience on a settlement deed is less, the possibility of a dispute is also less.
It's much lesser than legal.
And since it is a document registered in this manner, it will be a title deed unlike a will.
Yeah, will is only a statement or a legal declaration of the deceased. On the other hand, settlement deed is a perfect title deed.
Okay. So I think the explanation covered a lot of aspects. Probably the members may have questions. Will, there is a saying, a very famous saying: when there is a will, there is a way. The point here is, if we do not have the will to create a will or a planning for your succession, then that decision or that lack of decision itself can spoil the way and life of your legal heirs, creating a lot of disputes, unnecessary issues in the family. And in our office, we see a lot of disputes because the parent or the father or mother has not decided to do the right thing at the right time. It is time for handing over the session for question and answers. Over to you, James.
Just any questions?
Yes. Any questions, participants? You can raise any questions. This is the time for question and answers.
Joseph, you can ask.
Yeah, 1 minute.
There is a question.
Yes, there is a question in our Q&A box from CA Sudhakaran. Question is, undivided share in an immovable property, can he bequest his share to somebody outside the legal heirs? If so, what are the difficulties in that? That is the question. I think it's already explained. You can give to outside the family members also. But anything you can add on that? What are the difficulties? If there are any difficulties for that, whether how when it comes to the practical situations, how it shall be handled.
The undivided share in a property is a right or asset of a particular person. Definitely sell, mortgage, or even he can bequest that particular undivided share to a third person or a member of the family. There is no restrictions.
Okay.
I think it's clear.
Yes. Yes. Then can we create a trust through a will? Something like will trust or any form of trust through will.
See, creation of a trust through a will, the testator can appoint an executor, and he can be called upon, or one of the legatees can be called upon to create a trust by utilizing a particular property, or by utilizing a property or liquid money. He can ask legatees or a testator to create a trust. Executor or legatee create a trust. There is no such a there's no issue.
Can you explain the rights of the beneficiaries in the case of a will? I mean, is if we're putting it through a will trust, if you're creating a will trust, and what are the rights of the beneficiaries in enforcing that will?
See, what are the aims of forming a trust? I don't know. The testator can direct a particular beneficiary or legatee to form a trust as per his wish or decision. Normally, the rights and liability, rights and the rights over that particular trust will be based on the decision or the intention of the testator made the will.
Yes, there is a question. Yes.
Jose, there seems to be questions in the chat box. Probably you can.
You are muted, Jos. You are muted. Unmute it.
Yeah, another question is, can a will be a conditional one? Example, can I state that my property will be got by my wife, and after her demise, it will go to my son?
It can be a conditional one, but the condition should be legal one.
Pardon? It will.
Suppose one person bequests the property in favor of his son, saying that using this property, we should kill a particular person. Such a condition is not valid. So, condition should be a sound legal condition.
May I just clarify one thing there? I was the one who raised that question.
Yes.
Yeah. Am I audible?
Yeah, audible.
Yeah. So this was a practical question which came to me through one of my clients. Basically, what he wanted to do is ultimately he wants the property to go to his children. But during the lifetime, as long as his wife is alive, he wants the property to be owned by her. But he wants to ensure that she doesn't give it away to anybody else. So one of the suggestions which we gave was you create a life interest. Rather than saying that the property will be bequeathed by my wife and then it will go to the children, you create a life interest. But there he had another issue. He said that the property is mortgaged with the bank. So I want my wife to have a proper title, otherwise she will not be able to mortgage the property without the help of my children. So in such a situation, what would be the ideal way to draft the deed? Where I want my wife to enjoy the property during her lifetime, but I also want to ensure that after she passes away, it doesn't go to any third person, it goes only to my children.
Sir, it's not clear. Can you repeat? Echo is there. That's the issue.
Oh.
Yeah, no. The question is, the husband wants finally, gives the property to the children. But during the wife's time, he wants to give it to wife. Then after the demise of wife, it should go to the children.
It's possible. She can enjoy the property. A life interest can be given to the wife, during her lifetime, she can enjoy the property, she can take benefits out of the property, take income out of the property, and ultimately it will reach the children. She cannot transfer the property. That is the only question. That is the only issue.
Can she mortgage it for a loan?
It's not possible for her to mortgage the property without joining hands with the children.
Okay.
Ultimately, the property has to go to the children. She's only having the life interest. So, altogether, by the children as well as the wife, they can jointly mortgage the property.
They can mortgage or they can even sell, isn't it?
They can even sell the property. They can even mortgage the property. All need to be party to the documents. That is the only criteria.
Oh, that means even the children and mother, if they joined to the sale deed, then it is okay.
It's okay. We can
If
find
there
out.
is a life interest, then as a buyer, will not I have a problem that the testator has created a life interest, whereas the wife is selling it during her lifetime itself? Doesn't it go contrary to the intention of the testator?
See, life interest can be relinquished by her. She can say that I relinquish my life interest in favor of so and so person.
Okay.
It's a transferable. It is not. He can relinquish it. We can find out practical solutions for such issues.
Thank you.
See, but if the children are minors, what will be the situation?
Minors property. If minors property is there, you need to approach the district court by filing a GOP, get the sanction of the district court for transferring such property. Then, as per such order, you can execute a document. You get sanction of the district court in case of a minor.
That is the only solution, no?
That's the only solution.
Without going to the magistrate, nothing can be done.
No, you need to approach the district court.
District court, yes. Because there is a question of Alan, the question on Alan.
Is it in
Not in the chat box.
Yeah, that there is a few more questions. This is regarding the first question. Can the share of somebody we can, give to the outside the family? In that, because how can lay down the boundaries of that undivided property? I think this is the continuation of the first question. We asked whether we can transfer undivided share in the immovable property to outside the family person. So that in such case, whether it can be, how we can, show the boundaries of that undivided property.
I got it, Josh.
Yes.
I will put an example, Josh. I said I am the owner of 1 acre of property. Suppose I passed away without executing any will or any other document. My wife, son and daughter will step into my shoes. My wife will get 1/3 undivided. Son will get 1/3 undivided share, and daughter will also get 1/3 undivided share. It's undivided share over each and every inch of property. So they are the co-owners of the entire property. So my wife can, if she wants to sell, my wife can sell her 1/3 undivided share to Ninan for 50 lakhs, showing the boundary of the entire 1 acre of property. She can sell 1/3 undivided share.
Okay.
Boundary should be the boundary of the entire 1 acre of property.
Okay, that's clear.
Ninan, according to Ninan, he put another example. Like we are selling an apartment, we are getting undivided share when we are purchasing an apartment.
Yes.
The entire boundary of the land is being shown in the document as in the boundaries. So we are only getting undivided share.
Okay. Okay, that's clear. Yes. Is there any difference between a settlement deed and gift deed? What is the difference?
Yeah, there is a. I said gift deed, settlement deed is one of the settlement deed is one among the gift deed. There are a lot of kinds of gift deeds. Settlement deed is one among the gift deed. The difference between the gift deed and the settlement deed is this. Settlement deed you can execute only in between the family members. A father can execute a settlement deed in favor of wife, father, mother, son, daughter, or son of a deceased daughter, daughter of their deceased son, etc. So it can only be between a family member. That is the only difference. Love and affection is the consideration. It is not towards money. The document is or a property is being transferred to another towards the love and affection, not for money. That is the difference between sale deed and the gift deed. So settlement deed also, it is towards love and affection.
Continuing, what is the difference between settlement and will? Pros and cons.
See, explained in detail. Will the difference of the will and settlement deed we have already explained. Will is a legal declaration, rather a statement of the deceased, made in a white paper, which will take place only after the demise of the testator. The expenses is very little, 1,500, and it will take place only after the demise of the testator. The registration is optional, it is not compulsory. That is regarding the will. On the other hand, settlement is not a statement, it's a deed, title deed of executed by a person. It's a compulsorily registrable document. You can only execute a settlement deed in favor of a family member. There the expenses is 1,200 per lakh for the valuation of the property. It is compulsorily registrable document before the sub-registry within the jurisdiction of the property, and the revocation, cancellation, modification of the settlement is very difficult. On the other hand, the will is very simple, easy. That is the difference between the will and settlement. The main benefit of a will is that till the death of the testator can enjoy the property, he can sell the property, he can mortgage the property. That is the benefit of a will. But after executing a settlement deed, it's very difficult. I hope you understood the differences. Yeah, in a settlement deed, the executant can retain the life interest. The title will title and possession will go to the settlee or the donee.
Okay, thank you. Next question. See, we assign nominees for fixed deposit, LIC, etc., etc. Will it be enough, or we have to route it through will?
See, it's a very good question. Lot of arguments before the court. You have made, what is a nominee? That you should understand. Nominee is a person who can collect money from the LIC or from the bank. He is not entitled to take the money from the bank. He can only collect money from the bank and to divide the money or give to the money to the declarers. It's not the money of the nominee. Suppose Ninan's insurance policy, I am shown as nominee. If Ninan passed away, I go to the insurance policy, collect the money from the insurance policy on behalf of Prema and daughters. After the collection, I have to give to Prema and daughters. I am only a person authorized to collect money from the insurance policy or from the bank. And I say Allah, I need to give it to the legal heirs. So nomineeship is not an issue. Nominee ആണെങ്കിൽ പോലും ആ ബാങ്കിലും ഇൻഷുറൻസ് പോളിസിയിലും ഉള്ള തുകകളെല്ലാം ലീഗൽ എയ്ഡ്സിലേക്ക് എത്തും. വേറൊരാളാണ് നോമിനിയാന്ന് കരുതി ബുദ്ധിമുട്ടില്ല. നോമിനി ക്യാൻ ഓൺലി കളക്ട്. ദാറ്റ് ഈസ് എ സെറ്റിൽഡ് പ്രിൻസിപ്പിൾ.
Yeah, next. Yeah, next question. What do you mean by codicil?
Codicil.
Yes.
Suppose I executed a will in giving 3 bequests in favor of my son, wife, and daughter. After 5 years, I thought I need to give my son little more property. Then I need to modify it. For such modification, I can make a modification document by altering the bequest already made by me in the original will. This modification document is called as codicil. Got it?
Okay, that's clear. Next question is, what is the gift in contemplation of death? What is a gift?
Just that question is not very clear.
Yeah, it is written by Venugopal. What is a gift in contemplation of death?
Not very clear.
Venugopal, you can post some more detail in the question. The next question, we'll go to the next question. For a family of husband and wife alone, will or settlement deed is beneficial?
We said it depends upon the decision and decision of each and every family. I will prefer a settlement deed.
Okay. If the testator has received, one made a will, but son-in-law challenged the will, is it possible?
See, Josh, the execution at the time of execution of the will, the challenge comes the moment the will came into effect. It will came into effect at the date of death or the moment of death of the testator. After the death of the testator, any of the legal heir can challenge the will, saying that this is not the will executed by my father, or this is not the signature, mental capacity was not there, so the will was executed under coercion, threat, fraud, etc. This kind of contention can be taken before the court. There the court will take up the issue, take up the evidence will be taken, consider the issue and pass judgment. Any contention can be taken against will. Will is it's a risky document. It's a suspicious document.
Okay.
The evidential value given to will is much less than the other documents. The gift deeds, certificate deeds, sale deeds, those are pakka documents. Very rare cases it will be settled. But as far as will is concerned, chances for setting aside a will or is very high. Many cases the wills are cancelled or not relied or accepted by the court.
Okay. Okay, we'll come back to one question. We said there is some more clarity is required. That question is under section 56 to 5D of the Income Tax Act, a gift in contemplation of death is exempted, is an exempted income in the hands of the donee. So what are the characteristics of such a gift? That is the question.
But can you repeat once again, Jose?
Yeah, this is under income tax provision.
Okay.
If a gift is given, in contemplation of death, is exempted income in the hands of the donee.
Okay.
So, yeah. So, what are the characteristics of such a gift? That is the question.
See, as far as I got it, Jose. As far as a gift is concerned, we can compare gift with a sale deed. If I am selling my house to Ninan, say through a sale deed, it is towards consideration, the money he paid. There is a monetary transaction in each and every sale. But when it comes to a gift deed, monetary transaction is not there. All wills are executed towards love and affection. There is no money paid in a transfer under a gift.
Okay.
Yeah, this is the basic concept. As far as a gift deed is concerned, no monetary transaction. It is only towards love and affection. Suppose I am giving my house to my son. It is not for money. I am giving it for his future welfare and love and affection. I am not collecting any money from my son when I am transferring my house to my son. So monetary transaction is not there. It's not an income for me.
Another question. If a settlement deed is made by a senior citizen and it's written if his legal heirs are not properly taking care of him, but the property is mortgaged to a bank, can the senior citizen get the settlement deed revoked approaching the tribunal formed under the Act?
Jose, this is a lawyer's doubt. Very good question, Jose.
Yeah.
As far as a settlement deed is concerned, the Act, the Aged Citizens, Senior Citizens Maintenance and Welfare Act gives certain protection to the senior citizens. Suppose an aged father or a person who becomes senior citizen, transferred the property in favor of his son by way of a settlement. And later on, the son failed to maintain the father. He can file an application before the RDO for cancellation of the settlement deed. But recently, the Supreme Court held that if such recital is there in the document, then only such an application is maintainable. So, if in the settlement deed he made a recital to the effect that this is given to you, considering that you will protect and maintain me, and after that, that particular person failed to maintain the father and maintain the father, then only he can file an application before the RDO. Such right he should reserve in the document itself. Mortgaging, and the other part of the question, the issue of mortgage. It is always good for the bank to get the father as well as the son as borrower before giving the loan. Otherwise, bank will be in trouble. The senior citizen can ask for a cancellation of the document, and naturally, the son will keep mum, and there is every chance for setting aside such a document. But recently, Supreme Court, as per the Supreme Court judgment, it is only possible if such a recital is there in the document. So it is safe for the bank to make the father as well as the son as the borrower. So that issue is not there.
Okay. Another question for Christian succession. The proportion as per Indian Succession Act is mandatory, or is different share can be given?
Interstate succession means we are not executing any document. It is by law, without in a case where the person is not executing a document, and as per the provisions of the Indian Succession Act, the title will derive upon the legal heirs. There, the share is this: wife or the husband will get 1/3 share of the asset. Remaining shares will be equally divided among the children. If you are executing a will, a question is executing a will, he can give 50% to wife, he can give 30% to daughter, and he can give 20% to son. It is not as per the norms fixed by the Indian Succession Act. You need not follow the norms or need not follow the ratio fixed by the Indian Succession Act. It is your pleasure if you are executing a document.
So I think the questions are over. I think.
Baron sir?
Anything more? I think the questions are over. I think. Jose?
Yeah. Questions are over. No more questions in chat box or Q&A.
I think it was it's not thinking. It was really an excellent presentation. It was really Mathew as well as Ninan did a good job, an excellent job. I think almost all the participants who are present here today, they benefited from your this 1.5 hours talk and all the queries and the questions, different queries, questions, elaborating it, clarifying it. It was wonderful. I don't know how to thank both of you. I think it was Rubesh who brought this idea before me. I think thanks to Rubesh also. And regarding anything about will as a discussion seminar here today. So thank you very much for taking so much time and involving with us in this wonderful discussion. For the official vote of thanks.
It was a very really interesting subject. Basil and Ninan, both of them are very close friend of mine. We are there in Rotary connection. So I'm very happy to see both of you here on this online virtual CPE meeting. And very interesting subject, succession planning through will. There are a lot of practical issues. Even for a lot of clients, if they ask various questions, we can, we benefit from this discussion to answer all those questions. So it was a wonderful session, and thank you very much, Advocate Basil and Advocate Ninan, for joining us on this virtual meeting. On behalf of Ernakulam branch of SIRC of ICAI and all the participants here, I extend a sincere gratitude to both of you. Thank you very much. Then I also thank all the MC members who are present here. All the MC members are there, and all the senior members and friends who joined in this virtual meeting. There are a few announcements. As already our chairman mentioned in the welcome speech, on 2nd February, that is our budget is on the 1st February. On the next day, we are organizing a physical meeting, CPE meeting. The physical meeting after the outbreak of this pandemic. And this time it is in our ICAI Bhavan. From 9 a.m. to 1 p.m., we'll have an analysis of union budget on direct tax proposal as well as indirect tax proposal. On the direct tax proposal, CA Satyanarayan sir will be analyzing the new budget. And for indirect tax proposals, CA